Hello and welcome to Williams Mullins Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, and today I'll be joined by Nona Massengill and Ellie Clendenin, partners in our employee benefits practice group here at Williams Mullins. Hi, Ellie and Nona. How are you?
Hi, good afternoon.
Hi, Brydon.
Thanks for being here. We are recording this podcast the Friday before Thanksgiving, and this is the time of year, one of the annual traditions in our employee benefits practice, of preparing our end-of-year checklist, and we distribute this to clients and friends of the firm and to anyone, I guess, who wants a copy. And we thought it would be good to have a podcast to discuss some of the key end-of-year items in different areas of employee benefits law that employers need to be considering as we approach 2020. And so, Ellie, I thought I'd just start off with you and ask you, what are some of the key considerations for employers in the qualified plan area?
Yeah, so this year for qualified plans, there's nothing really big that we have to be all scrambling for the end of the year. There are some required amendments for defined benefit plans, and it's for plans that offer a payment that is a part annuity, part lump sum. Those are required by the end of this year, but realistically, most plan sponsors will have done them already because they had to be administrated a couple years ago. So that's probably not a big one. The other big guidance that came out this year was, of course, hardship regulations. Those are not amendments that need to be done this year, but administratively, employers this year could remove the 6-month suspension on deferrals. So they could start now.
So if they did that in 2019.
Yes, they could do that. They could remove that suspension. The other thing that has come out that we put on our checklist, not an amendment, but something plan sponsors should be aware of, is the new DOL rules on electronic disclosure of plan notices. This is going to be very welcome relief for plan sponsors because the DOL is kind of finally realizing that the old guidance that said that plan sponsors could only mail electronically to participants who access email as part of their normal job duties is outdated because everyone has email. So the new default under these proposed rules is that by default, employers can electronically deliver or post on a website any DOL notice. So that is a big relief for plan sponsors that we're having to do large
Really
mailings.
modernizing the way we can communicate with participants. Well, thank you, Ellie. Nona, turning to executive compensation and equity-based compensation, what are some key items for employers to consider as we approach 2020?
Sure. Well, there's an annual reporting requirement that applies to the exercise of incentive stock options and share transfers, the initial share transfer of a share of stock acquired under an employee stock purchase plan that's subject to Section 423. Probably more common is the requirement relating to ISOs. This is an information reporting obligation that's similar really to a W-2 or a 1099, and the deadlines are really in line with those requirements as well. But the forms that are relevant are forms 3921 and 3922, and the deadline for reporting to employees is January 31st, 2020, just like a W-2. There are IRS requirements as well, and paper filing to the IRS would be February 28th, electronic filing March 31st, all of those in early 2020. One other thing that is a change that happened during 2019 and that will continue to apply, but it is a new method of compliance, is the requirement to file Top Hat plan registration statements online. Previously, those could be done in paper form or online, and those typically are filed within 120 days after a new non-qualified plan is adopted.
All right, well, thank you, Nona. I guess I'll kind of wrap up our discussion by talking about some considerations for health and welfare benefit plans. As noted in a prior podcast, the final health reimbursement arrangement regulations were issued over the summer, and those regulations become effective January 1. These regulations allow employers to offer health reimbursement arrangements to employees who have purchased individual health coverage either through an ACA exchange or outside of the ACA exchange. So non-group health plan, employer-provided group health plan insurance coverage can still qualify an employee to be eligible for a health reimbursement arrangement. And so that's a significant change for employers, and often smaller employers who are too large to qualify for the qualified small employer health reimbursement arrangements, but still want to provide some assistance to employees who are purchasing health insurance in the individual market. So those regulations become effective January 1. There is a 90-day advance notice requirement, so employers have to consider the timing of when they implement the health reimbursement arrangement under these regulations to make sure that the notice is provided in a timely manner. Some good news is that the Patient-Centered Outcomes Research Institute, or PCORI fee, is expiring. So this is a fee that was implemented with the Affordable Care Act to pay for the Patient-Centered Outcomes Research Institute. The fee is a per participant fee that that employers have to pay for their health insurance. The fees are due at the end of July every year. And so this year the fee amount is $2.45 per participant. That fee is due on IRS Form 720 by July 31, 2020. But this is the final year that fee is being assessed. So for plan years ending after October 1, 2019, the PCORI fee no longer applies. And then finally, I just want to make sure that I mentioned that once again, as always, the Form 1095-Cs are due. They will be due to the IRS by February 28th, 2020, or March 31, 2020 if they are filed electronically. And employees must receive their Form 1095-Cs by the end of January 31, 2020. So that'll wrap up our discussion of end-of-year considerations for employee benefit plans. I'd like to thank Ellie and Nona for joining me. If you have any questions or suggestions for future episodes of this podcast, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team as well as past episodes of this podcast and legal alerts. Additionally, our end-of-year checklist is available on our website at the employee benefits page at williamsmullen.com. Be sure to subscribe to this podcast to be notified when our next episodes post. Thanks for listening.